Welcome to the third webinar in this year's Canadian Trademark Series. My name is Daniel Anthony. I'm a principal in trademarks at Smart & Biggar. I'm joined by my colleague and principal, Mark Biernacki. We'll be your speakers for today. The topic is trademark and copyright enforcement online. I'd just like to start with a few housekeeping notes before we get started. This presentation will be about 40 minutes long, and we're going to follow that with a question and answer session. So if you have any questions during the presentation, get them in as we go by clicking the Q&A icon in Zoom and typing it in. Don't use the chat because we won't be looking at that. Today's webinar will be recorded, and after the webinar, you will have access to the recording if you want to go review it. We'll also share our slides with you. At the end of the webinar, there will be a survey. We really appreciate any feedback you might want to give us, positive or negative. And before we get started, I'd like to do a land acknowledgement. In the spirit of reconciliation, we respectfully recognize and acknowledge that the land that we are meeting on, and Mark and I are in Quebec and Ontario right now, and really the land that all Canadians live on, work on, and enjoy is the traditional territory of many First Nations, including First Nations, Inuit, and Métis people. Now, let's start with a brief introduction of Smart & Biggar. Here's Mark and I. I practice in trademark, copyright, and internet law, both prosecution and enforcement. Mark has done it all in his career at Smart & Biggar, over 25 years, patents, trademarks, copyright, litigation, and is an amazing strategist. Our firm is Canada's leading IP firm. We have 5 offices across Canada. We excel all areas of IP law, over 130 years in business, and our team comprised of about 100 active lawyers and about double that in support staff. Here's today's agenda. We'd like to walk you through 3 hypothetical scenarios based on some of our client experiences. We then like to discuss why protecting IP is so important, though I doubt many of you will need to be convinced of that. We'll look into proactive and reactive tools to protect IP on the internet and online. And then we'll apply those to the original scenarios, followed up by questions and answers. Let's get into those 3 introductory scenarios. So the first one I'll take, it's called the hijacker. We have a brand owner. They've developed a new brand and a product which they're selling primarily online, and it's highly successful. They've put a ton of work into their listing, their reviews, the photos, etc. Once they're up and running, the counterfeiter hijacks these online listings by either copying the listing and offering the same product, but they don't have the real thing, or on a platform like Amazon, pretending to offer the product and get merged in as a seller on that Amazon listing. Of course, since they don't have authentic product, there's negative customer reviews, slow shipping, poor quality, and they're taking sales from the original brand owner. This is much more prevalent now than ever. With COVID, the online shopping environment exploded. In addition, I've noticed a trend that some of these platforms are a little more hesitant than in the past to just shut potential infringers down. They'll often ask for bona fides, like a trademark registration, etc. So we'll explore what this brand owner could have done differently and what they can do now. I'll pass it over to Mark for the second and third scenarios.
Thanks, Dan. So the second scenario is the trademark troll. This scenario has become more frequent and prevalent since Canada amended its trademark law in 2019 to eliminate the requirement to file a declaration of use to obtain a trademark registration. As a result, some bad actors are now able to apply for and register on other companies' trademarks in Canada without ever having to use that mark themselves. Once registered, the bad actor can disrupt the brand owner's business and try to extort money from them in exchange for instance, assigning the registration over to them. This scenario can unfold as follows. A company runs a successful online store on Amazon.ca through a branded storefront. Perhaps it's the company's only retail channel in Canada. And like many companies, it may never have applied for and registered its brand as a trademark in Canada. So a troll applies to register the company's own brand in Canada. And since the troll has never used the mark in Canada, the company might be entirely unaware of the troll's application. Once the troll's mark is registered, it pounces. It uses takedown requests through Amazon.ca to shut down the company's online store, which cripples its business. And then it demands payment to assign the registration to the company. What could the company have done differently to avoid this mess? And what can it now do to solve this problem? We'll take a look at some of those questions towards the end of our presentation. So now let's look at the third scenario. The media pirate. So media piracy is a potential problem for pretty much any company that creates, sells, and distributes digital media in Canada. One possible scenario goes like this. A very successful media company creates and sells video games. They discover a Canadian individual operating a website that provides links for downloading pirated copies of its games and also offering mods for cheating in the games. The website is hosted outside of Canada. The links lead to various cyber lockers, also located outside of Canada. The website has tens of thousands of members. This is a huge problem. Downloading of pirated games is causing the company to lose significant sales. And the cheat mods, are ruining gameplay in several of the company's online games, which is causing it to lose subscriptions. What options are available to this video company? Again, we'll take a look at some of those options at the end. But before we do, let's ask a basic fundamental question, which is why protect IP in the first place? The answer, in a word, is value. More particularly, it's to protect value. Now, many business people will say that their company doesn't have any valuable IP. And most of those business people will be wrong. Let me explain through a story and by looking at some statistics. So the story is this. Former CEO of Coca-Cola, this was back in the Cola War days in the 80s, was asked about the importance of IP to the business. He answered that if you took away all of Coca-Cola's physical assets, all of its inventory, manufacturing facilities, bottling facilities, distribution centers, trucks, office buildings, burned it to the ground, but you left Coca-Cola two things, its secret formula and its trademarks. He said the company would be back in business and making a profit within a year. Contrast, however, he said, that if you let Coca-Cola keep all of its physical assets, but revealed its secret formula and took away its ability to use its trademarks, he said Coca-Cola would be out of business within the year. Let's look at some statistics. So according to Bloomberg, in 1975, the value of intangible assets accounted for 17% of the market value for all S&P 500 companies. 17% is pretty significant when you're probably talking about trillions of dollars of market value. But that was in 1975. As of 2020, that figure had risen to over 80%, and the relative value of IP is only continuing to rise. So if you think that IP isn't viable to your business, chances are you are undervaluing the importance of it. So Dan, why don't I turn it back to you and you can go over some of the reasons or places where value is derived from IP.
Thanks, Mark. These are just a few examples, but I think there's some major ones where companies can understand that IP is driving value. Like, where does that 80% come from? So the hallmark of intellectual property, whether it be a trademark, copyright, or patent, etc., is exclusivity. They're monopolies. So that's the first major benefit you get with IP. Secondly, particularly for trademarks, it enhances the price of the products and services you can sell. Once you've developed goodwill, people will fundamentally pay more for an Apple computer or Lululemon yoga pants than what is an equivalent product because they trust it. And often it has a certain cachet value, even if the products are of the same quality. So there's a price premium that you can charge with intellectual property. Next, intellectual property is an intangible asset. You can buy it, you can sell it, you can license it. It really helps to work the asset, to have it recorded, registered. It enhances company valuations. Been dealing with a lot of corporations in the last few years, some of them more startup, which have been getting acquired. And during that acquisition process, or even for valuation on the stock market, if they own patents for their technology, or if they own trademarks for their brand, or if they have things recorded and organized, that enhances company valuation and share price. Especially for startups, but even for major companies, you can use IP as collateral for loans. And that's often what the bank will ask for if there aren't a lot of other assets. And finally, optimization for tax purposes. You'll often have a situation where a company is operating in multiple jurisdictions. Sometimes they can put the IP in one jurisdiction and license it into another with the royalties flowing back. And if you can move profits or royalties into a lower tax jurisdiction, this can be an advantage to the business. So those are some of the areas where IP is driving this value, which we're talking about. Now, let's move on to the third part of our presentation, which is to talk about some of the proactive tools before you have an infringement, whether online or otherwise, that an IP owner can invest in. I'll take the first row of this slide and Mark can take the second row. So the first proactive thing someone can do is to identify what their trademarks and copyright are. I have worked with several clients on audits, and it's surprising what comes out of the weeds. A slogan that was never registered, some domain names, copyrights and key materials that are just floating around. So we need to know what they are. And certainly on an ongoing basis, the different parts of the company, whether it be marketing or creation, need to be talking to legal or otherwise to track these assets. Secondly, timely registration. We've already been hearing about the effects of not securing protection, people getting into the office before you, causing trouble. Third, proper marking, putting that C in a circle, that copyright notice, putting that TM or that R in a circle for registered trademark. It keeps competitors off of your lawn, so to say, if they're acting in good faith. It teaches customers that these are the source indicators, and it enhances your protection. Ensuring ownership. It's quite common that a company will be doing contracts, maybe they're purchasing an ad campaign or a logo's been developed. Well, who owns it? Are there proper assignments taking place with third-party contractors, employees? If there's a partnership between two companies or a parent and a subsidiary, are we tracking who owns the asset? Are we organizing a paper trail for that chain of title? It can be very important. And the last one that I'll talk about is things like the Amazon brand registry or other online registries where you can secure a declaration that you're the owner of this brand, and it gives you enhanced ability to monitor and take action against third parties who might be misusing that brand. Mark, I'll pass it over to you to go over the second row.
Thanks. So the first item in the second row is RFAs, requests for assistance. What are these? Well, when the Combating Counterfeit Products Act in Canada was brought into force in around, I think it was 2015, it gave Canadian custom officers the power to detain goods that were suspected to be counterfeit and to share information regarding the importer with the trademark or copyright owner. but a condition for using the system was that the trademark or copyright owner had to file an RFA with customs. And an RFA is a simple form that identifies the business's trademarks and copyrights and may include additional information that will assist customs in identifying counterfeit products at the border. Now, even when trademark or copyright infringement is happening online, so long as the infringement involves some physical product crossing the border, then an RFA may be a useful proactive tool in helping to combat that piracy. So next tool, anti-counterfeiting measures. These are anything that makes it more difficult for bad actors to counterfeit a product. Examples include certificates of authenticity, unique product codes, secret product features, holograms, and virtually any other feature that makes it difficult to copy a product. Next are technological protection measures, or TPMs. These are any technical features that control access to a work or prevent copying. An example of an access control is a paywall for a website. An example of a copy control is encryption. If done well, TPMs can be a very effective mechanism in entirely preventing or at least delaying online piracy. And even when they don't, or where online piracy is taking place, having TPMs in place provides potentially additional causes of action under the Copyright Act for circumventing those TPMs. Next are smart contracts. These are any contracts that provide companies with additional protection over and beyond traditional IP rights. Examples of smart contracts that could help prevent online piracy may include restrictive terms of use in software and media licenses that terminate if the user makes unauthorized copies, and restricting the scope of user licenses to a specific jurisdiction or country. And with the growth of blockchain-based technology, smart contracts, in my view, are becoming a more important proactive tool in combating online piracy and infringement. And the last is monitoring the register and the marketplace. This one's simple, it's effective, it's inexpensive, and it can be used to identify and allow companies to address problems at an early stage. For example, simply monitoring the trademark register may help a company identify a trademark troll so they can protest or oppose a bad faith application before it becomes registered and can be used against them to hold them hostage. Now, as important as proactive tools are, sometimes they're not used or they might not be entirely effective in preventing bad actors from infringing IP rights. And in those cases, we need to react. And so now I'll turn the mic back to you, Dan, and you can take a look at some of those potential reactive tools.
Thank you, Mark. I'll do some reactive tools and I'll allow Mark to add on to that. One of the reactive tools which we've been leveraging quite a bit for the past 18 months since it was introduced is expedited trademark examination. Canada has a substantial backlog in our regular trademark prosecution timelines at this time. But the office, as a result of that, has introduced a plan that if you find yourself in a situation where you qualify, there's 3 factors, but you qualify to get the office to prosecute faster, you can file an affidavit explaining why you've met their test, which typically involves an active infringement of the brand, substantial online marketplace problems, or customs and border problems. So if you have one of those situations, you can outline it in a short affidavit and receive examination within 10 business days. So that's incredibly fast. You can even file an application and file your request on the same day, and then you'll have your first office action within 10 days. It still has to go through advertisement and issuance, but ultimately within a few months, you'll have an issued Canadian trademark registration. In addition, for copyright, Canada has always had the benefit of an expedited process. Our copyright registration certificates issue within 24 hours of filing, and they're received by regular mail about 2 weeks later. So if you need to get a copyright protection and you want your certificate so you can assert it in some sort of online enforcement, that can be readily done through Canadian copyright. Opposition proceedings, similar to many other countries, Canada has an advertisement period, 60 days in Canada, and you can oppose any trademark with which you have issues. And the trademark can't be enforced, the third-party one that is, until the registration issues. So during that opposition period, you're not really at any risk of enforcement by, let's say, a troll. Now, if they had use-based rights before you, it would be a different situation. But for someone who hasn't used the mark, a pending application is really of no effect. Takedowns. Canada doesn't have a DMCA like the United States. However, because the markets are so integrated, virtually every Canadian ISP, let's say Shopify, for example, or a web host in Canada, they follow a process very similar to the DMCA. And if you identify a copyright infringement, or frankly, even a trademark infringement or phishing or fraud, they'll generally take action. That's quite effective in Canada. Domain name arbitration, of course, you can do a UDRP. In Canada, we have our own UDRP providers, though you can also go to other countries, but that's a global system for many domain extensions. And if it's a .ca domain extension, we have the CDRP, which is unique to Canada, similar to the UDRP, with a few important differences. So it's good to get Canadian advice, but very similar process to recover domain names which contain trademarks. Border enforcement. Mark's already mentioned the RFA program, where you can write the simple form to customs, just list all your trademarks and copyrights in one simple form. And if they happen to see a problem, they'll contact you. But in addition, if you ever get inside information that there's a particular shipper, a particular port of entry, or a particular shipment, we can communicate that to border enforcement, and they will make efforts to look into or to seize that particular shipment if you can supply them with that inside information. And finally, there's the Canadian Anti-Counterfeiting Center. There's a collection of legal representatives, but we also have our anti-fraud center through our police, where anyone who's a victim of online scams or fraud or otherwise can make a report. This can often lead to escalation to financial payment processors like MasterCard, PayPal, to shut off the taps to protect consumers. So that might be applicable in a situation where you've got a brand and they don't really have the ability or frankly responsibility to shut down every scam. But if you see your brand name, let's say, being used in an insurance scam that people fall victim of, some sort of email scam, you want to educate customers, hey, if you see something, why don't you call these anti-counterfeiting center or fraud center, and they can take action. So Mark, I'll pass it over to you to continue with some of these reactive tools that we can use.
Thanks. So the next reactive tool that should be considered are cease and desist letters or demand letters, C&Ds. In my view, these may be the single most effective tool in the reactive toolkit. They are remarkably effective and relatively inexpensive. In my experience, C&D letters resolve well over 90% of all IP disputes. In addition, they are sometimes necessary or helpful to lay a foundation for other steps or claims that you might want to assert. For instance, for some copyright claims, it may be necessary to establish knowledge of the copyright, which can be achieved by sending a demand letter and setting out the asserted right. In other cases, you might be able to use a C&D letter to bait a bad actor into revealing their intentions by making a demand for a huge payment of money. However, one point of caution: in cases where you need to maintain the element of surprise, such as where you are concerned that an online infringer will disappear, hide their tracks, or transfer control of the website to another person who might be beyond the jurisdiction of our courts, then you might want to pause and consider before sending a C&D letter. Because once you do, you're putting them on notice, and they might react to that. So the next reactive tool is legal proceedings. This is often the first reactive tool that companies think of, but it's often the tool of last resort. The reality is that legal proceedings are generally slow and they are expensive. So this tool should be used cautiously and sparingly, but sometimes the reality is there is no alternative. Using legal proceedings to go after online infringement could be its own topic. But some basic questions that you might want to ask yourself include the following. Will the court have jurisdiction over the bad actor? Where is the bad actor located? Are they located in Canada? Where are the infringing activities taking place? Is there any connection to Canada? What are your available claims? Are they copyright? Are they trademark? Are they contract? Anything else? The types of claims that you want to assert may restrict where you can bring your lawsuit, for instance, in the federal court versus provincial courts. What relief do you want to seek? Do you need injunctive relief? Can you wait until trial, or do you need that injunction right away? Do you need an Anton Pillar order? For instance, are you concerned that the bad actor may conceal or destroy their evidence? If so, then an Anton Pillar order might be something that you want to pursue. What sort of damages will you be seeking? Compensatory, statutory, punitive? How will you commence the proceeding? Will you do so by way of action or application, which are distinct options and paths in Canada? If you need discovery and want to put additional financial pressure on the other side, perhaps an action is the way to go. If you would prefer to proceed expeditiously, you don't need discovery, and you want to conserve costs, then maybe an application is the preferred means of proceeding. There are, of course, many other considerations that you will need to reflect upon before commencing legal proceedings, but these are just a few. So turning to the last reactive tool on our list, which I suppose in some respects is also a proactive tool, is educating consumers. Arguably, there would be no piracy if there were no consumers for pirated products. And there are at least two aspects to this problem. First, some consumers are genuinely duped into buying pirated products. They think it's the real deal. Educating such consumers to be able to discern between genuine and pirated products could reduce the market for such pirated products. My daughter, for instance, loves to shop for vintage brand name clothing, and she's very concerned about getting authentic clothing. So she shops through places like The RealReal, which authenticate the clothes, and she has educated herself on how to tell between a genuine or counterfeit product so that she can avoid the counterfeit products. So that's one aspect to education. Now, the second aspect of the problem is that some consumers know but don't care that they are obtaining pirated products. Perhaps a lower price is more important to them than quality or respecting IP rights. And educating such consumers about the negative effects of piracy, which go well beyond simply lost profits and may include things like health and safety issues, links with organized crime, poor working conditions for pirated products, may go some way to addressing this second aspect of the problem as well. So this brings us to the end of the reactive tools. So at this point in the presentation, Dan, I'll turn it back over to you to take a look at the first scenario.
Okay, Mark. So the first scenario, if you remember, was this online hijacker. So I'll give you a bit of background on the client situation that inspired this scenario. Right as COVID was ending, we had a client from Asia, and they had created a factory to make N95 masks long time ago when there was a SARS crisis that affected Asia and to some extent Canada as well. And so they had a large capacity to make high quality masks. And one of the owner's relatives came to North America to sell these masks in the North American market. And so they'd ship them to North America, huge volumes, and create a store on Amazon. The masks they looked good, they were reputable, they were high quality. And so there was a high demand, thousands of dollars a day of sales of masks through the Amazon platform. And then as it was up and running, the hijacker comes in and tells Amazon, opens an account and says, I have the same product for sale. And they go for a lower price, such that Amazon pushes the consumers towards that product within the listing that our client has prepared. They're right there together as two stores selling the same product. That's how Amazon functions. And very shortly, they were getting complaints. The masks were showing up in baggies, like Ziploc bags. They weren't even authentic. They were delayed. So the whole listing is getting trashed. And this client didn't have Canadian trademarks for the brand or copyrights. So the first thing they could have done is they could have filed for those trademarks earlier. They could have tried to get into the Amazon brand registry in the first few months while they were building up their reputation. And they could have thought about how to educate consumers and build in these indicators of authenticity. You know, our products are all shipped from California, or it's not the real thing. If it's not delivered in 3 days, you know, don't fall for fakes. There's one source. So the reactive steps that we took with the client were to immediately file a trademark application, immediately put in an affidavit of how the brand was being effective in online marketplaces, getting that 10-day examination, securing copyright registrations in 24 hours for the look of the packaging and whatnot, then getting into the Amazon brand registry, filing the proper takedowns, and also educating customers as we went in response to these complaint reviews and by changing the listing to explain that any shipments coming from Asia, those are the counterfeits. There's one seller, it's a sole source product, it ships from Vancouver. And the customs recordals, because you've got product coming from Asia in this case, it's going to have to come through a custom. And so we could work on that element. So that's how we dealt with this scenario. And it's quite interesting how we were able to leverage. I think ultimately it took about 2 to 3 weeks to resolve the issue. It was costly for the client, but they did manage to recover their full online portfolio and to continue to make those sales. Mark, I'll pass it over to you now.
Great, thanks. So the second scenario you might recall was a trademark troll. So this is where you had a bad actor that had registered a company's trademark and then used it to take down their online website and extort payment. And this is loosely based on a case that we handle. Now, what could the company have done to avoid this problem in the first place? So the first thing is they could have had a timely filing of a trademark. If that company had filed an application for its own trademark when they started to use it or were contemplating of using it in Canada, and they had this application in the register, that alone could have potentially avoided the entire problem. Because if the troll later filed an application for the same mark, the company's earlier filed application or subsequent registration, if it had matured to registration, may very well have blocked the troll's application from proceeding to registration at all. Second thing that the company could have done is to monitor the marketplace in the register for use or application to register any infringing marks. Now, in the case that we were handling, our client was monitoring the marketplace, but because the troll was never using their mark, had no intention of using their mark, they never saw that as a problem. It just didn't enter their radar. But they weren't monitoring the Canadian Trademarks Office. Had they been doing that, then they would have learned of the troll's application, and it would have allowed them to possibly protest in some narrow circumstances, or if the application was allowed and advertised, it would have allowed them to oppose the application and block it at that point. Which brings us to the third proactive tool, which is opposing the application. Again, this step could have resolved the entire problem. However, before you can oppose an application, you need to be aware of it and know that it's been advertised. So this tool depends in part on monitoring the state of the register. So if one or more of these proactive tools weren't taken, and the brand owner and company find themselves in the unfortunate situation of having their online .ca retail store shut down, what can be done? Well, first thing that can be done is to send a demand letter. In this case, there isn't a concern that the troll is going to disappear. It's simple, it's inexpensive. Doesn't always solve the problem. It didn't in our case. Second reactive tool that should be considered is commencing a summary non-use cancellation proceeding. Canada has, in my view, one of the best, most efficient non-use cancellation proceedings for trademark registrations in the world. In our case, this option wasn't available because the troll had just recently registered the trademark. So it wasn't vulnerable to non-use cancellation, which is only available once a mark has been registered for more than 3 years. But even if it was, the company may not have the luxury of waiting for the non-use cancellation proceeding to resolve itself, which can take some time if the other side is contesting it and fighting it. So a third reactive tool to be considered and that we used in our case was commencing litigation. Now, we needed to consider whether to proceed by way of statement of claim or application, which was one of the considerations that I raised. And because there was no need for discovery and we wanted to move as swiftly as possible, we decided to proceed by way of application. And as a result, we were able to get a hearing on the merits and a decision in the matter of months rather than possibly years if we proceeded in the normal course by way of a statement of claim in an action. In terms of relief, we were obviously seeking to expunge the registration on a variety of grounds, such as bad faith, abandonment, since the troll had never used it and there was no appearance that there was any intention to use it, non-distinctiveness based on confusion with our client's prior used mark, similarly non-registrability due to our client's earlier use. We also sought an injunction based on our client's prior rights so that this bad actor couldn't ever engage in similar activities. And importantly, in this case, because certain statements were made to Amazon.ca in the takedown requests, specifically representations that our clients' goods that were being sold on its own website were the counterfeit ones, we were able to bring a claim successfully under Section 7A for making false and misleading statements. And that allowed us to get a substantial damage award to go after the troll and in fact cover all the costs of the litigation. So this was a case where certain steps could have been taken and were not, but we were able to get a fairly swift and satisfactory result. So turning to the third scenario, this is with respect to the media pirate. And this happens in all shapes and forms in Canada. And this is really a collage of a number of cases that our firm has handled over the last few years. And you recall, this is a case of a media company makes, designs, sells video games. And there is an individual in Canada that operates a website that is providing links to cyber lockers in other countries where people can download pirated copies of games, and is also making available mods for these games that allow users to cheat, that ruins the playing experience for regular consumers. So what are some proactive steps that the company or media companies in such circumstances may wish to take? Well, the first is ensuring that they own copyright in their media. It sounds obvious, and there are certain presumptions under the Canadian Trademarks Act that confer ownership of media created by employees to the company, but that doesn't apply to independent contractors. And many media companies that employ independent contractors are sometimes surprised to learn, when they want to enforce copyright, that they might not own copyright to their works. So it's useful if you are operating in the space and copyright is important to your company, that you have the proper mechanisms in place to ensure that you own the rights in those works in the first place. Next proactive step is proper marking, use of the copyright symbol that Dan was talking about. Not only does this put people on notice of your rights, it also can form a foundation for certain claims under the Copyright Act, and can be a basis for seeking increased damages on the remedy side. Timely registration of copyrights and trademarks. Registrations confer numerous benefits, so it's useful if you are deciding to go after an infringer, that you do an audit of your IP, and if there are certain marks that you haven't registered or copyrights that you haven't registered, that you do so. As Dan said, you can register copyright in Canada in less than a day, and if there is litigation that's being contemplated, you can expedite examination of the trademark application and take steps to register your trademarks much quicker than the current process is in Canada. You may be able to use technological protection measures to create insurmountable or very significant barriers to the copying of the media. There's a number of companies in this space that do a very good job in that area. And even when they don't succeed, even when the pirates are able to overcome those TPMs, they form a basis for going after the bad actor and can create a claim that can result in very significant damages. There's a case that we handled on behalf of Nintendo against a company that was dealing in circumvention devices for Nintendo consoles, and we were able to obtain a damages award that was over $10 million. Request for assistance, brand registry, those are also important proactive steps depending on the nature of the bad actors' activities. So turning to reactive steps, what can be done? Well, so I mentioned expediting trademark examination and registration. If you don't have all of your rights registered that you want to assert, that's an important step. Takedown might be an option depending on where the infringing media is being distributed and offered online. For instance, if it's being done through things like Google Play or the Apple Store. But in some circumstances, that option isn't available. If the activity is taking place on platforms that are located abroad or openly disregard things like the DMCA or takedown requests. C&D letters are certainly an option, and it's an option that we have exercised in some of these cases. But in the one case where we had an individual that we knew was based in Canada that was operating a website, that we were very concerned that if we put that person on notice, control of that website would be transferred to someone outside of the jurisdiction. And although we had a very solid claim against the person in Canada, it could have been a Pyrrhic victory insofar as the activity could have continued unabated, and it might have moved to a jurisdiction where we would have had very limited means to take reactive steps. So in that circumstance, a decision was taken to litigate, and a decision was taken to litigate ex parte without notice to the other side. We filed a statement of claim under seal, and we brought a motion for both an Anton Pillar order and an interim injunction, whereby we were able to enjoin the individual from transferring control of the website and ownership, and we were also able to secure information and essentially copies of the website, so that if it was transferred or deleted, we had preserved that evidence. We were also able to obtain significant statutory damages. In many cases, bad actors in these cases don't defend, and you're able to proceed quite swiftly to default judgment. And a very positive development, I would say, over the last 10 to 15 years in Canada is that amount of damage awards, both compensatory, statutory, and punitive, has increased significantly, where you would rarely see damage awards exceeding six figures 15 years ago. Now damage awards exceeding $10 million are not uncommon. And we've had quite success against such media pirates over the past.
Yay for Canadian courts.
Yes.
Okay, Mark, thanks very much for that. Let's jump right into our question and answer. I see a lot of you have posted questions, which I thank you for those. Mark, maybe I can throw one at you and then I'll take one and we'll proceed like that.
Sure.
One of our attendees is asking about the application of maybe US case law, recent US case law, in a Canadian case. Is US case law, binding? Is it authoritative? Maybe comment on that. I'm just thinking of a case I read, a couple of weeks ago with the Metaburkins, let's say.
Right.
There's a US case. How would that affect us here in Canada?
So it's certainly not binding. However, courts can and have looked to US decisions for guidance. And so particularly where an issue has not been considered before in Canada, it can be a useful guidepost.
Okay, thanks. So a bit of, persuasive effect, in appropriate circumstances. And that's going to be quite common, actually, that a decision might be decided first in the US because there's a larger body of case law. Second question here, someone's asking how trademark and copyright infringement are dealt with in Canada, given the territorial nature of claims. How does jurisdiction get involved, especially where you don't really know the source of the infringement? So I can take that one.
Sure.
Firstly, when it comes to copyright, remember that even though you might get a Canadian registration with the Berne Convention, it's effectively global, your copyright. So that's useful. But as far as when you should be acting in Canada, if there is harm in Canada, for example, if any online listing is offering shipping to Canada, targeted to Canadian customers, even if it's a US company, if it's in China, it doesn't really matter. We would have jurisdiction to complain to any platform, whether it's YouTube or Amazon, from Canada, saying, hey, we've got this Canadian trademark or this Canadian copyright, and this content is directed to our consumers. So in that regard, it is considered use of a trademark in Canada if the mark appears on the internet and is benefiting Canadians. Now, that wouldn't be the case if it's just like a restaurant in Australia that a Canadian can look at the menu, but it's 100% in Australia. But when it comes to online marketplaces, you would typically have jurisdiction and leverage in Canada if it's targeted here. Okay, here's another question for you, Mark.
So before we move on to that, it's on the topic of multinational infringement, where you have infringement taking place in many different jurisdictions at the same time, which is not uncommon. I think it's often important to reflect on and ask yourself if there is a particular choke point for the infringing activity, that if you're able to attack that, you will be able to do a real dent in the problem. So the example that I was talking about was you had this Canadian individual that was running a website. Even though the servers were based outside of Canada, we had this Canadian connection. And if we could use that to shut down the website, that would effectively solve that problem. Whereas if you tried to go after the problem in every jurisdiction where it was going on, it would just turn into a game of whack-a-mole.
It's a good point. And I will say, in my experience, when it comes to the platforms, they don't really care. For example, we had a recent case where Alibaba is the party that was hosting the content. The infringers in Malaysia, the victims are global, and Alibaba wasn't particularly concerned that our client was Canadian or American or Japanese. Once we filled out their forms to advise that it was a scam, that it was copyright, and that it infringed some right in the world, they just enforced their policies. So it seems like certain platforms are not so worried about jurisdiction. But then on the other hand, with my complaints to Google, they'll often say, well, before we take down these Google ads, where do you have trademarks? And we're going to geo-restrict the Google ads. So some care and some don't. Okay, next question. Mark, I'll pass this one to you. Do smart contracts always contain IP licensing terms? Do you need separate licenses and assignments in some cases? And there's a bit more detail here about circumventing this with brands on the World Wide Web, with blockchain and whatnot. Could you comment a bit on that?
Yes. So, okay. So this is at the edge and beyond my level of personal expertise. I don't have a lot of experience with crafting and dealing with smart contracts, but I will say, no, they don't always have to contain licensing terms. That's merely one example of a smart contract. And they can come in any shape or form, and really you're only limited by your creativity. What you're trying to do with the smart contracts is to plug a hole that may exist with the existing IP regimes. And so an example might be gray market goods, where if you buy, there's a lot of businesses that have arisen around the globe that essentially buy genuine goods in one jurisdiction and sell them in another jurisdiction where the price is much higher. They're doing an arbitrage. And simply by putting contracts in place, and these are not licensing contracts, they're merely distribution contracts. If you have control over your distribution chain, you restrict in what countries, what locations your distributors can sell your products. So they're not allowed to sell these products abroad. That goes a long way to helping control gray market goods. So that's an example of one where there's no licensing aspect at all. It's purely contractual. In terms of blockchain, again, this is, I've read about some sort of theoretical options. I don't have any personal expertise in this, but I've heard of examples of where licenses or products might be sold along with an NFT that accompany that, and that becomes a badge of authenticity or a mechanism to verify the authenticity of that particular work. They're useful in some circumstances, less useful in others, but that's another example of a type of smart contract which might be a useful tool in this space.
Thanks, Mark. I'll just add to that. It's buyer beware on smart contracts and blockchain. You're going to have to look at what the smart contract says, and it might have a copyright assignment, and it might have nothing, no license, no assignment. So definitely, as a consumer, you'd educate yourself. And I don't think there's any standard that you could, such that you could make assumptions. Okay, two people have asked a similar question, which is about what constitutes, because we talked about three ways you could get expedited examination: border problems, an active infringement where you're thinking of taking a court proceeding, and substantial problems in online marketplaces. So they're asking, what are substantial problems in online marketplaces? So I think as a firm, we filed well over 100 expedited examination requests. Essentially, they've all been accepted, maybe with the exception of one or two in rare circumstances. And it doesn't have to be a lot, but this is a sworn affidavit under oath, and it has to be true. So an example would be even a single infringer that you can identify in an online marketplace, and you can say, hey, I'm in this online marketplace. I have this infringer. I'd like to take action, but owning a trademark would be important for that. So that would be an example. It may even be an example where, let's say you're on Amazon and you wanted to participate in the brand registry, and there's been a history of problems, even though you don't have one right now. And as you try to get in the registry, it's asking you for your trademark. So there needs to be something real, something present, but it doesn't have to be, when I say substantial problems, it wouldn't have to be like at least 10 infringements. As long as there's something real that you want to take action on, the office to date has been quite flexible here. And so I definitely encourage you to reach out to your Canadian counsel to talk about expedited examination if you think you might have a hook and you might qualify for that.
Yeah, so just to amplify your point, the substance of the problem goes to the quality of the problem, not the quantity.
Thank you, Mark. Okay, so we have another question here about generative artificial intelligence platforms, inherent risks associated with, let's say, copyright, and how the data sets are created, maybe with web scraping. Do we have comments on this? Are we giving advice on this? And what about insurers ensuring the AI created works? So what I can say is this is a brand new field. There are no Canadian legal cases that have been issued on the topic of generative artificial intelligence, copyright concerns, web scraping. So we simply can't comment on it. I can certainly tell you that to the extent that, what I would say is that the Copyright Act is the Copyright Act. So where a work is substantially similar to a prior work and was copied from it, that would be likely an infringement, as it's always been. And if there were large works that were copyright protected, let's say they're behind a paywall or they're in an environment where you're not supposed to copy them and they were downloaded and copied, then you may have a recourse of action. So at present, the situation that we're in is we would apply traditional copyright theories and principles. And if something has been copied and taken, there may be a course of action. But as a fundamental rule, I wouldn't say that, let's just say looking through Wikipedia, educating yourself as an AI, and then generating new works would automatically be an infringement, because the new work might be more of an independent creation. So this is kind of a moving area, moving target, no certainty at all, but traditional copyright principles should apply. Do you have anything to add, Mark?
Yeah, so I would add, echo everything you said. Wild, Wild West, rapidly evolving field. I think it highlights the growing importance of the raw data, and it's, I mean, Google's business model is based on data, but now these data sets that are being now used to train these AI platforms, that's a whole new value for them. And there are mechanisms in the Copyright Act, for instance, technological protection measures that can be employed to protect that data. And so that if it is scraped, if those TPMs are circumvented to get that data, to build a data set, even if the data itself is not copyrighted, the fact that you have circumvented a TPM might give rise to a cause of action under the Copyright Act.
Thanks, Mark. There's two questions we haven't gotten to, but we've reached the end of our time. I'm going to use my discretion to just answer these questions for those of you that have to go. you can drop off the call. It's fine. And we will be sharing a recording of it. And I just want to thank everyone in advance for their attendance, for those of you who need to ditch exactly one, but I'll read these last two questions. So one of our questioners says, what tools are most effective against the defamatory reviews and feedback on online platforms? Maybe they're not true, they're from customers, or they're from competitors. How can we deal with that? So certainly in Canada, if it was happening in Canada or it affected a Canadian owner, Section 7A of the Trademarks Act prohibits false and misleading statements. So does our Competition Act. So we would be able to take action if there was a specific competitor that was leaving these defamatory statements by a C&D letter or legal complaint. Also, we can, in my experience, what I do is I write to the platform and explain the issue. Now, if we're just talking about a few consumers here and there, usually you have to respond to their review and say, hey, we've tried to reach out to this person. They're not being reasonable, or they're commenting on a different product. But as a general rule, we do have laws that prohibit false or defamatory product reviews or comments, and they can be enforced through takedowns, C&Ds, and legal proceedings. Maybe, Mark, I'll give you the last question, which is this. How are infringements jurisdictionally taken care of for the metaverse? You got victims globally. These metaverse platforms and virtual goods can be global. So how can we take care of them in Canada? Do you want to comment on enforcing on the metaverse?
Yeah, so it's a great question. And I don't think there's a good answer. I think that, again, this is an example of where the law is in the process of evolving, and we don't have really many, if any, good signposts. But I think looking at the evolution of simply the internet provides a good example or proxy for how you might approach these sorts of problems with respect to the metaverse. Because moving from a brick and mortar to an online store isn't that much different than from an online store to the metaverse. You still have real consumers that are somewhere. That provides a hook for a jurisdiction. You still have companies offering these products or services, even if they're in the metaverse. Those companies still exist somewhere and are offering these services through a platform. That platform is another hook to a potential jurisdiction. So there are all those touch points are places where you can argue that you have jurisdiction, and we'll have to see how the courts look at those problems to get greater guidance.
Thanks everyone for attending. There's a survey that automatically gets sent to you. We love feedback, positive or negative. We appreciate you joining us today. Our next session's in the fall. Have a good one. Thank you, Mark, as well.
Thanks, everyone.